Good afternoon, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. I wanted to get on today to give some pointers about a local case that I'm reading and how things work in regards to their entire system. And like I've been explaining, almost everything we deal with in this commercial society is a tax issue. Everything has to be assessed a tax first before it can be commercialized. And in so doing, this is one of the things that this guy used in defeating a case. And we're going to start reading about it. It's United States versus BH appellee. Now BH, I don't know if that's Black Hawk, as in Black Hawk County, or the actual defendant. Because it seems to be a private action because of that, because the defendant isn't actually named in this, but it will tell you he is from here in Waterloo, Iowa, where I'm at. And what it says is, United States appeals the district court's grant of summary judgment to defendant BH in the government's civil declaratory judgment action seeking to keep BH from reacquiring guns and ammunition. So the government's declaratory judgment seeking to keep BH from reacquiring guns and ammunition was reversed and remanded. In other words, he got his guns back. And the background is in August of 2002, and it says involuntary. In August of 2002, involuntary hospitalization. Now what I want to point out here is later on we're going to see another word or term that shows that this is inconsistent. Involuntary hospitalization proceedings were initiated in the Iowa District Court for Black Hawk County against BH, a 60-year-old resident of Waterloo, Iowa. As part of that process, a doctor evaluated the mental condition of BH. What I want to point out here before we go any further, part of the process that is required and due is that the defendant has a right to seek his own counsel, which is his own counsel in all matters, including medical. So just because a doctor evaluated the mental condition of BH does not mean he was qualified to do so. The qualification of doing so must be done by the defendant BH. They can't just assume a position and say, okay, well, we're going to evaluate the mental condition. That's called a medical experimentation. An evaluation is a deduction of certain facts. Those facts being lineated by medical practice. And they found him to be suffering from schizophrenia. Now, if these legal writers had any knowledge of the terms and conditions they're using, they would know that that is inconsistent with involuntary, because suffering means that you volunteered. And involuntary is inconsistent with volunteering to suffer. So let's get on to the next thing. The doctor determined. Again, if the doctor made that determination, where was the determination that he was qualified to make that determination on behalf of BH? Did BH give that consent? And if one is found to be not competent, then can they be subjected to any practices, experimentations? If the voluntary consent of the human subject is absolutely essential, do they have anything that they can do with somebody that isn't able to give consent? Can they make such determinations? I believe this is a very valid question to pose. So let's get on with the next thing. That BH was a threat to himself and others, and recommended BH remain hospitalized while undergoing treatment for mental illness. So we have somebody that determined that somebody else is suffering from schizophrenia and has done so involuntarily. And that doctor who determined such made those determinations because he felt that BH was a threat to himself and others. And therefore, again, upon his recommendation, BH remained hospitalized while undergoing treatment for mental illness, which is a description in mental practices or medical practices. A search warrant without consent and without probable cause, but only based on somebody's evaluation. A search warrant was issued in Blackhawk County pursuant to Iowa Code Section 809.11c, and law enforcement seized. And the only way anybody can seize property of another in this country under military rule is for military necessity. That military necessity is enforced in the courts through trials, also distinguished as an experiment. Thousands of rounds of ammunition, 12 handguns, 8 long guns, and over 150 pounds of gunpowder. Notice, people, this guy having gunpowder was either refilling his rounds or using black powder guns. In other words, this is indicative of somebody that might possibly be collecting antique long guns, handguns, and rounds of ammunition that are no longer dispersed. Point here being that if he is a collector, then he is not importing and exporting, he is in possession. Very important things to realize here. From BH's residence and vehicles, stating that the residence was in Commerce and that the vehicles are in Commerce, even though both are stationary. On September 4th, 2002, following a hearing pursuant to Iowa Code Section 229.12, subsection 1, a judicial hospitalization referee for the Iowa court, not for BH, again, not for BH, found that BH was seriously mentally impaired. A judicial hospitalization referee under compensatory, pecuniary compensation, under licensure, not appointment by a grantee, appointing them as trustee, but merely a judicial pecuniary compensation capacity only for the Iowa court. The Iowa court is the one that paid them. They are the ones that were in contract. They are the ones that exchanged equal consideration and equal benefit. In commerce, in interstate transportation, interstate trade, interstate commerce, interstate trafficking, and determined that BH was seriously mentally impaired. Iowa Code Section 229.13, subsection 1, provides that if upon completion of the hospitalization hearing, where did the hospitalization hearing come in up here, folks? Involuntary hospitalization means that there was no hearing. So again, they are trying to use codes if upon completion of the hospital hearing. Where is the record of this hearing before he was involuntarily hospitalized? Right in, on, and for their record, they give evidence of their incompetence themselves. Involuntary, yet voluntary. No hearing, if upon completion of a hearing. Come on, people. The court finds. The court found. I don't give a damn about the court's opinion. By clear and convincing evidence. Really? Really? You saw the hospital hearing records? You know that the suffering is voluntary, but yet the involuntary hospitalization occurred without a hospital hearing? So you find by clear and convincing evidence, I find by clear and convincing evidence that these courts are incompetent. That the respondent, if it was involuntary, how is he named a respondent? How else is he supposed to respond except involuntarily? Has a serious mental impairment. And just because he doesn't volunteer to your stupid incompetence doesn't mean he has serious mental impairment according to your clear and convincing findings. The court shall order. Is that a commercial order? Who drafted the order? Did BH draft that order, or did somebody else draft that order? That's what I want to know. The respondent committed as expeditiously as possible for a complete psychiatric evaluation and appropriate treatment as follows. Committed. Who committed him? Were they competent? The court shall order respondent. Again, clear and convincing evidence shows that he's not a respondent. It was involuntary. Placed under the care of an appropriate, meaning they have to appropriate funds. And the record of this respondent is a statistical record of a resident or facility licensed to care for persons with mental illness. Persons being fictions can't have a mental illness. I'd like to bring any psychiatric and English major to the stand. Any one of them that is licensed appropriately. Please step forward. Please show your incompetence. Or substance abuse on an inpatient or outpatient basis. What I'd like to note right here is substance abuse. They're going to use the substance of their legal instrumentalities in an abusive way. That is the substance abuse. Let's be very clear about the terms and conditions placed on the roots of words. Your stance is not subordinate to the use. Your stance is not subordinate to the outside use. And I don't care how they use it or what substance they use. They shall not use it against you. And it says on an inpatient or outpatient basis. This comes in handy. The referee ordered that BH be immediately committed as an outpatient to Black Hawk Grundy Mental Health Center for evaluation and treatment. Wait a minute. Didn't they say he was already evaluated and treated? Isn't that what they started out with? On October 24, 2002, BH petitioned the Iowa court for return of his arsenal seized from him. The court denied the request, noting that BH was still committed for outpatient treatment and that the return of firearms could. I don't give a damn about your opinion because so far it's proven to be incompetent and inconsistent. Endanger BH, the public, and law enforcement. Law enforcement is a verb. Could endanger law enforcement. That is not naming anything but a thing, a concept of the enforcement of what they're doing now. Their inconsistent, babbling incompetence. And I pose a challenge right now to any attorney to step up and destroying this document. This is in the public domain and this is their babble. Any psychiatrist, any English major, any judge, any lawyer, any president, any clerk, any bailiff, any sheriff, any person, any man that wants to come up and prove other than what I've been stating, please do so, because I don't want to sound like the babbling idiot, particularly since I'm doing it with such great passion. See, that's what qualifies me. I'm earnest. I'm going to tear up every word, term, and condition to show you where it actually comes from. If you don't believe surrender is actually a voluntary action, look it up. You don't find it, keep looking. You don't find it, come ask me. I'll show you. I source everything. That's my challenge. If you can't find it, then you ain't looking good enough because I already found it and can prove it. It's called grammar, people. Grammar. On April 10th, 2003, the referee discharged. Same thing. Same thing that happened to me when I walked out of jail and that judge discharged. That That's a full discharge, people. They discharged you and your person from custody. And that's all they have is custody, people. They hold you in custody. They cannot maintain that they can possess you. BH again petitioned for the return of his items. On November 6, 2003, the Iowa court granted the request, relying on testimony from the executive director of the Mental Health Center, recognizing BH's hobby of gun collecting and noting that the return of the firearms would present no danger. That's the executive director of the Mental Health Center. No danger. He just rejected everybody else's statement of presenting danger. No danger. The court rejected, he didn't have to qualify it as no danger to himself, the public, and law enforcement. He just said no danger, would present no danger. The court rejected the county attorney's argument that 18 U.S.C. 922 in conjunction with Iowa Code 809.5 prevented the return of the guns and ammunition to BH Iowa Code Section 809.5 Section 1 provides in relevant part. And again, in relevant part, like I said, these courts are martial courts. Seize property which is no longer required as evidence. And that was the use that they were using it for, was evidence. It wasn't used in commerce, and they admitted it. Or for use in an investigation. May be returned to the owner without the requirement of a hearing, provided that the person's possession of the property is not prohibited by law and there is no forfeiture claim filed on behalf of the state. Possession as opposed to their custody and holding. They have to first have a forfeiture claim, a military forfeiture claim, saying that they have to possess the property for their use and not to use the property for their custody and holding in pecuniary compensation of storage, which is all insurance. And that's what it was. They held this man in storage while they got pecuniary compensation from possession of his person. Emphasis added, Section 922G4 of 18 U.S.C. provides that it shall be unlawful and it's a danger to law enforcement. It shall be unlawful for any person who has been adjudicated as mental defective or who has been committed to a mental institution to possess in or affecting commerce. Again, proving that not only are their mental institutions commercial, but possession in or affecting commerce means they have to hold custody of it in a commercial and pecuniary compensatory manner. That is the subject at issue here. Everybody here is operating for pecuniary compensation except BH. The Iowa court reasoned that Section 922G4 did not apply because BH legally possessed the property before proceedings against him began in August 2002. Not only that, but the property remained in Blackhawk County and was never shipped through Interstate Commerce since that date. 3, he was never adjudged mentally defective. 4. He was never committed to a mental institution, but was instead committed for outpatient treatment, and had since been adjudicated to be no longer seriously mentally impaired, and, like said, present no danger. The court ordered the seized property returned, barring an appeal, on December 9, 2003. The order was not appealed. On November 19, 2003, the county attorney faxed a copy of the Iowa court's order of November 6 to the Iowa State's attorney. See, it wasn't appealed. The court ordered the seized property returned and barred an appeal. Barring an appeal. On November 9th, since they couldn't appeal to the state court, the attorney faxed a copy of the Iowa court's order of November 6th to the United States. There is no evidence of significant earlier interaction or communication between these officials concerning the BH matter. Interaction. There is no evidence of significant earlier interaction. Every interaction in a compensatory manner for pecuniary compensation in commercial paper used in the fiat currency of United States is a significant earlier interaction, and it is continuous. If the courts and the government and the personnel operating in this capacity do not recognize this, they are the ones that will get caught up in these interactions with people like myself, pointing it out as clear and convincing evidence of significant earlier interactions. Every last one of them is based on an obligation or security of the United States. Period. And that includes all communications between these officials concerning the BH matter. On December 5th, the United States seized most of the property from the Blackhawk County Sheriff's Office as part of an investigation. See, they didn't appeal. What they did was they entered a second investigation upon the same issue. Double jeopardy. Into whether BH was in violation of 18 U.S.C. 922 G4. And this here is a good one. Unlawful acts. And when we see, it says, except a licensed importer. He was not importing. He was not manufacturing, and he's not a licensed dealer. To engage in the business of importing, manufacturing, or dealing in firearms, or in the course of such business to ship, transport, or receive any firearm in interstate or foreign commerce. Interstate or foreign commerce is defined through the meaning of terms. Interstate or foreign commerce, under Section 1821 U.S.C. 921, the term interstate or foreign commerce includes commerce. It must be commercial. Period. No ifs, ands, or buts about it. No criminal charges were filed against BH because the government concluded that the firearms and ammunition had not been returned to BH at any time since the mental health proceedings. And thus, he had not yet violated Section 922. And so they're using this as a prevention to return them, saying that once he gets them, he can use them in interstate commerce, and they have to prevent that. Their own admission that it is a hobby and they are antique guns and gunpowder and things of the such prove that they are not in interstate commerce. The investigation complete. The government sought to dispose of the property, concluding it could not return the property to BH because it was contraband under Section 922. Really? Really? Contraband? Let's look at contraband, folks. You have contraband cigarettes. Goes down, talks you all about them contraband cigarettes. And then there's contraband firearm. A firearm with respect to which there has been committed a violation of the National Firearms Act, which is under 26 U.S.C. Chapter 53. Machine guns, destructive devices, and certain other firearms. Certain means it has already been ascertained, and the most certain one is that it is a tax. Special occupational taxes. If you are not one of the occupying forces, you are not required to pay a tax. See, the occupation is the armed forces. They're the ones that are required to pay that tax. Tax on transferring firearms. If you are a hobbyist and you are collecting them, you are not transferring them. Tax on making firearms. If you are not producing firearms for import or export, in other words, buying and selling, you are not required a tax. Every last one of these issues in regards to contraband, commerce, courts, it is all a tax issue. Every last one of them will revert to the tax issue. Thus, the government brought a civil declaratory judgment action in the United States District Court. District Court is an administrative court, not judicial, for the Northern District of Iowa, seeking a declaration to that effect. The district court determined that collateral estoppel barred the government's request, given the state court's ruling on the applicability to BH. The state court already ruled that it's not applicable because it was not in commerce. So therefore, that's the collateral estoppel, barring the government from anything else, because the only thing the government can operate in is that commerce, and it must first be proven by the tax. The court concluded that, one, the state court's determination was essential to its holding, and two, the government was in privity with the county attorney. In privity means it was a contract or a private agreement and had nothing to do with BH. In that the county attorney was the virtual representative of the government. That the county attorney was the virtual representative of the government. This is what I keep telling everybody. That county attorney is the fraud. Accordingly, the district court denied the government's summary judgment and instead granted summary judgment to BH. Now the only problem here is this record, even though everything's been remanded and BH got his shit back, he hasn't asserted the final judgment. It's still a summary judgment. If I knew who this guy was, I would have recommended to him to make that final judgment on the public record. However, the court itself has made a public statement in granting a summary judgment. This should be held as a final judgment. And then it goes on and discusses, says, arguing that the collateral estoppel does not bar the district court from considering whether Section 922 G8, G4 applies to BH because the government was not in privity with the county attorney. The government was in privity with the county attorney at all times. Again, this is not a special circumstance. Where was it earlier where we spoke about regular business with each other? Anyway, I'm going to post the link to this so everybody can read it. It's a very important case to realize. Again, like I said, these medical practitioners, these judges, none of these guys have an actual assignment. And what they did here, involuntary hospitalization, yet claimed to be suffering from schizophrenia. It proves their inconsistency, their incompetence, and they're subjecting somebody to a medical experimentation under their practices by having him remain hospitalized instead of returning him to family or finding family member to get the proper consent. Their own admission says that he was involuntarily hospitalized. And again, the first point of the Nuremberg Code says that, and again, my entire family calls me a lunatic, folks. So if it was up to them and in the court, they could just put on the public record that I'm a lunatic and the court agrees with them, and now they've got a medical doctor that says they agree with them. This is the fallacy of their language. I will stand strong in it. I don't care if you call me a lunatic, you better prove it. Because even in your own documentation, I don't care if you think I'm suffering some kind of mental illness because I don't agree with you. That may be your own mental illness known as cognitive dissonance. I suggest everybody read a book known as book titled Hitler's Willing Executioners. This is a prime example of exactly that book. We have a Supreme Court, United States, versus a private man, and everybody in between. And the private man, through his own promulgation of, I don't know how he did it. It doesn't state his words. It just states the court's opinions. But it shows that everyone in between, all of these doctors, everybody involved in this case, pushing forth all of this bullshit. This is babble right on here. 150 pounds of gunpowder. Why else would somebody have 150 pounds of gunpowder and at 60 years of age and have never been on the scene of a criminal record of anything? Has no criminal record. His family determined that he must be a lunatic at 60 years of age getting involved in all this stuff. He's retired. He wanted something to do. He picked up a hobby. For crying out loud, what does that make a man lunatic for? What does that give anybody a reason to commit him for a mental evaluation? See, you can't just come by force, even if your family members and doctors and politicians and lawyers and judges come in by force and say, well, we're going to commit you to a practice. We're going to do some experimentation on you. We're going to experiment with these words on paper. See, that's what it is. It's all babble. Pure and simple. Anyway, I'm going to post this link in the chat section when I get done. I'm going to post my other forum links and stuff. Please hit the PayPal link, share some love, but make sure you share all the information and links as well, folks. We got to get people to comprehend what's going on here. Every last one of these documents these people are putting out, and this is, like I said, this is United States Supreme Court level, and I just pointed out at their level, right away, involuntary hospitalization and suffering. How can one be suffering and yet be involuntary? Suffering when suffering is a voluntary act. Before Woolman, Beam, and Benton, these three judges, incompetent for putting out such a writing. Incompetent. Circuit Judges Robert Lee Teague, U.S. Attorney, Cedar Rapids, Iowa, for Appellant Michael K. Lamar, argue for Cedar Rapids. These guys are all incompetent. The doctors involved in here in making these evaluations and then transferring it to another one to make an evaluation and treatment. These guys are all incompetent. They made judicial decisions of their own incompetence. They judged themselves incompetent and placed it on the record for me to tear up. And if any one of them has a question, it's 2006. I imagine a lot of these guys are still around, and I don't care. Come on, step forward. Show me that I'm the one babbling and not you. Show me that I'm the one that is wrong here. Show me. With that, I'm done. If it weren't for you guys, I wouldn't be doing this. God bless y'all.